Good afternoon, everybody. Welcome to, this is the Art Salon. If you're here for the restroom by accident, it's that way. My name is Josh Baer. With me is Peter Stern, one of the nation's, if not the world's, leading attorneys in the field of art law, and both in terms of litigation and transactional kind of matters. He's counsel for McLaughlin and Stern in New York. He's the chairman emeritus of the Volunteer Lawyers for the Arts, which is a great organization that does free legal work largely for artists. And welcome, Peter.
Thanks, Josh. And Josh was nice enough to invite me to speak today. He has been in the art world for over 30 years. It's partly genetic in his case. And currently he's an art advisor to many important collectors in the art world. And equally importantly, he is the author and publisher of a newsletter which goes to many of the most important people in the art world. And
Now our topic today is 10 legal cases about art. People like lists, so we tend to think that way, and that tends to be a tradition. We've broken them up into a few different categories that we'll address, and Peter will try to do a good job of explaining what these cases are about, and my job is to sort of explain to the audience why these might be important to you. So to understand better how these things might be important to you, I'd like to know how many people in this room are artists, by show of hands. How many people would say collectors? Okay. How many people would say dealers, advisors, consultants? How many attorneys? Okay. So there's a little mix of each, and there must be, and the rest, who would say other? Do we have a show of hands? Or too shy to say? Okay. So some of the category, we're going to talk about the resale royalty issues that have been going on. We're going to talk about authentication, and then we're going to talk about some general contractual issues. So, and we're trying to deal with things that are fairly relevant to 2011 with the facts. So, Peter?
Right, thanks. The first thing I want to say is that there will be no visuals today, we were asked, and so you're just going to have to cope with Josh and I, and we will stay clothed. And another thing, when we were making this list of 10 cases, really, even cutting it down, there's probably about 20 that we could at least talk about, and that's kind of corresponds with the escalation of prices in the art world, which is really one of the reasons, the main reason there are so many cases is because the prices in the art world have, and what's at stake has become so great. We thought that the Resale Royalty Act cases would be of particular interest. They are among the most recent. There are 4 of them that I could mention. 2 of them they're all in California because they relate to the California Resale Royalty Act. California is the only state in the country that has a Resale Royalty Act, and basically it provides that a seller is obligated to pay 5% of the net profit on the sale of artwork. There are a number of conditions. But the most important features about it are that it applies to sellers who reside in California or sales that take place in California. So the first piece of advice is that if you reside in California, you should move. And but in any case, the cases that I'm mentioning are 2 cases that were started by the Sam Francis Foundation. One is a class action against Christie's, and for equal time, the other is a class action against Sotheby's. There is a third case that was recently filed, which the named plaintiff is the Robert Graham estate, and they are suing about 9 dealers, some of whom are exhibiting at this fair. And as a result of the filing of those cases, it came out that about a year ago, another case was filed. This is an individual case which was filed by an artist named Mark Grochon against a collector named Dean Valentine. So, Josh, if you want to talk about...
This is a situation that's been debated since the 70s, when a lot of the world's most important artists got together and tried to form a group and lobby with Congress to get these rights. And back then, it was not so clear that the beneficiary of these big resales was largely these very wealthy artists. And as a work gets resold for millions of dollars in profit, probably the people least needing this resale are those very artists. So these acts are meant to protect poor, starving artists, but in fact, they probably don't. And I think it's interesting because for you artists, what you're doing is not the same as writing a piece of music that's played on the radio. You're making an object that has a discrete transaction. I give you this glass of wine, you give me money. In my opinion, that should be the end of the story. As someone who buys and sells art, I'd like the artist to maybe give me 5% of my losses if I lose money on a case.
More than that, because it's all a very limited downside, but the upside is unlimited.
Yeah, so
I should pay half of it.
What's interesting about this case also in terms of what's going on is a lot of these are efforts to get the auction houses to take on this responsibility. And there is some logic because they do that in Europe, where the auction houses do collect what the European Union says are these resale royalties. But if you're an artist, I think you should be opposed to this act because it will discourage people from buying emerging or lesser known artists' work. If the risk is, if I hit a home run, I have to share the profit, it will discourage collectors from buying works of newer artists, I believe.
Well, also, it's important if you're a dealer in California, because it's the only state that has this law, it inevitably, if the law is enforced, is going to impact sales of art in California. If I'm a consignor, I'm not going to want, I'd rather sell in New York than in California. And so I don't think it's good for California, for the art trade in California. Also, just to mention, they've been trying for years to enact similar legislation in New York, but so far that has not happened. It will be interesting to see if it does happen, whether then the art markets will move to Chicago and Dallas.
It'll just put people underground. It's very hard to know what private transactions happened. I think these cases aren't very strong. I know in the San Francisco case, they sued a gallery for reselling works that they'd bought from the San Francisco estate themselves. They didn't even know. It's like, how can you sue me for reselling something I bought from you? So those cases they may lose because they have bad cases, or they may lose because the law is bad, or it's very hard to have one law in one state and a different law in 49 other states. But
well, we're going to watch it carefully because it raises constitutional issues about interstate commerce, and I won't bore you, but some very interesting issues.
So the next big subject we want to talk about is authenticity. And we've broken that into sort of two groups. If you've been reading, there's been a lot of about the Warhol Foundation, and in fact, they've just recently declared that the Warhol Foundation Board is no longer going to authenticate Andy Warhol works of art. And then we'll talk about some non-Warhol cases.
So basically, we can divide authentication cases into Warhol and everybody else. On Warhol, I could have made a list of 10 cases that relate to authenticity of Warhol's probably certainly more Warhol cases than any other artist. Most people are familiar with the most important case is the case involving Joe Simon, paintings referred to as Double Denied, but I'm not going to talk about that because it's pretty common knowledge. Another case, though, that's interesting was decided about a month ago, which upheld the Warhol Foundation's rejection of a drawing. I'm sure the court was influenced by the fact that the person who was trying to get it authenticated had paid $78 for it at Tepper Auction House, which is now defunct, and was insisting that it was genuine. Another example with Warhol are the Brillo boxes, which were authenticated by the board, many of them, and have now been declared to be not Warhol. What else can I say about Warhol?
The last one's interesting because it was, instead of what was thought to be true being false, it's the opposite.
Right. Well, another case where Warhol authenticated something which was not resolved was a case I was involved in which an artist, Gerard Malanga, claimed that he had created a work that was authenticated, but that case was settled.
So why does this matter to you? Well, if you're a museum curator or a dealer or an expert, the last thing, in my opinion, you should do is become a member of one of these authentication committees, because you're opening yourself to incredible professional liability. You can, and people do get sued on these committees. On the one hand, people want to do it because it gives them more access to data and more power, but it's really exposing themselves to tremendous conflicts with these things, and it's a very dangerous spot to be on. Why it matters to you in general is, if you're a collector, is it enough to have a certificate of authenticity?
Well,
if it's later invalidated, what does that mean? If it's in Warhol, they would argue you can't buy something without that, there is no market. And the legal, from what I could read, the judges say, well, just because they say it's not real doesn't mean that you can't have a market for it. And I don't think the court is understanding the art world marketplace. So,
well, moving to a more general area on authentication or authenticity, I don't think it's gotten enough press here, but recently in Germany, an artist, sort of, named Wolfgang Beltracci was convicted of forging 14 paintings that were said to be worth about, I think it was $22 million. What hasn't been really publicized is the fact that it really involved 53 paintings, so it probably involves 100+ million of paintings. And many of these paintings were in fact authenticated by the leading experts on the artists. One of the principal artists was Max Ernst. There are about 5 or 6 of his attributed to him, and Mr. Beltracci was a very good forger. If you want to.
well, then what's the role of a scholar? And scholars can be wrong, and they can be fooled, and we have the best of them, and some of them don't like to admit they're wrong, and some of them are more open-minded. So each case, each artist, as you go back into history, you have different issues. I would say I've come across, there's questions, largely works that come out of Russia, and you see these certificates of authenticity in Russian, and then you realize that every name on that, if you pursue it, they're all dead. If everybody on the list is dead, that's a red flag to me. But they may be legitimate, and who knows what was really going on with Malevich nearly 100 years ago. There's certain artists that are very, that may be easier to forge. So forgery is one thing. But also, if you have a solid wall drawing, which has the right to do it, and you lose your certificate of authenticity, even though it's real, you have a problem because they don't want to give it to you. So if you have one, put it in a safety deposit box, because if you lose it, you're screwed.
I'd just like to take a minute about the Beltracci case. Der Spiegel wrote an article about it, and there was a section that I thought people might appreciate, and it goes as follows. And Beltracci has helped expose the absurdity of the art market, in which paintings ostensibly by famous artists are traded almost always as speculative investments. It is not the aesthetic value of a painting which decides whether it is worth millions, but the question of whether it was produced by a known and fashionable artist. Beltracci also demonstrated how experts and art dealers, driven by greed and vanity, could declare forged paintings genuine without hesitation. That in itself provoked some sympathetic coverage from journalists following the case. The victims who were duped were not poor pensioners, but greedy art dealers and super-rich collectors. But anyone who now believes that auctioneers, dealers, and buyers will in the future consider the authenticity of a painting with much greater care is likely mistaken. I thought that was
What I'm
a
curious
biased view, but
is how many, if you had a painting that you looked at every day and you loved for 20 years, and the next day somebody told you it was a fake, how many of you would then say, gee, I don't like that painting anymore to look at? I mean, the object hasn't changed. Who would no longer like it? Just me? I'm the only one who would look at it differently. You'd all say, I still love those. It's not a Cezanne or it's a Fodigliani. It's the neck's a little funny, but I still love it. Or would you look at it and your perception, I think your perception changes as your understanding of the actual history of it does. I'm not even talking about the financial part, but just the visual thing. People, I bet you all would look at it differently and say, I don't really like it anymore. In fact, I never really liked it that much. My art advisor made me buy it. It was
Josh,
me. And
you liked it so much.
Suddenly not available on the phone. Right. Now, there's some other authentication cases that had different.
Mention them briefly. A leading big case that was settled recently was involved a Motherwell. Case was called Kalala versus Daedalus Foundation, and it's a case where the Daedalus Foundation had given its seal of approval by saying it would be in the catalog. Resale said that the work would be in the catalog. Then subsequently, a number of works of the same hand and period and type came to their attention, and they realized that it couldn't be, and they had it tested scientifically, and it turned out it could not have been painted by Motherwell. So the lawsuit, they changed their opinion, and a buyer who had relied on their first opinion sued, and the case was recently settled.
What you might not have read is that a lot of this revolved around the Nördler Gallery, which has been in existence of 163 years, but as of today, has closed.
Did it close?
It's closed.
Uh-huh.
And because of this case and the potential liability that they might have. So it can bring down an entire 163-year institution. One of the
I don't think it was this case, but I think it's aspects related
to this
because
case.
this painting was not necessarily the only painting involved and the only artist involved in what was going on. But I can't say that Nördler was the party there.
They're involved with aspects of this case, and it can. So that's just something I read this morning. That surprising to read that gallery is.
Really. Another interesting case recently that was decided is a case against Christie's called Marchig versus Christie's. It involved a painting, a drawing, which may or may not be by Leonardo da Vinci. A woman had consigned it in 1997, and Christie's had said that it was by a 19th century German artist. 12 years later, several experts decided that in their view it was by Leonardo. And the complaint says that as a result, Mrs. Marchig was deprived of property worth $150 million. That case, Mrs. Marchig lost. That was primarily on the basis of the statute of limitations. But it is an interesting case that I think it shows that you need to not just consult one expert about an object, but you can speak.
How many people have bought something at auction ever? Have you ever read all the details in the back of the catalog about what you're agreeing to and what they're agreeing to? It's pretty complicated. When it was made, what do they warrant, what will they stand behind? And the more powerful you are as a buyer, the more they'll stand behind their deal.
Right.
The Brillo boxes, they refunded a number of sales to some clients. And that's a decision that they sometimes will make, but it's very confusing. And if you send it to your attorneys, if they're not a specialist in art law, they won't understand what the auction houses are doing, much less what's a gallery warranting, because they're just writing, Alex Katz painting price. They're not really saying very much in this. So it's a dangerous field, and I'd say what you need to know is the art world's a tricky place, and you have to operate a lot on faith or have a good attorney back there.
Well, echoing what Josh just said, not about an excellent attorney, but one of the important things about the art world is that it is so unregulated. Art dealers are, while they complain about auction houses and transparency, it's extremely non-transparent. And so a buyer and a seller have to be very careful in how they conduct their business. And that comes into another topic, which has to do with consignors, consignments.
Can we skip to a related thing of, we're talking about authenticity. I'd like to talk about the appropriation cases, because then you have authentic, not authentic, and then you have what's a work of art. And this is the Richard Prince case. And I think that's a better segue, maybe.
Well, that's fine. That's fine. So I think everybody's probably read about the Richard Prince case, which is a copyright case brought by Mr. Carreau. And Richard Prince clearly used his photographs. And in the trial court rendered a very damning opinion against Carreau. It's now on appeal, and it's very divided. It's a very controversial case. The art world is really divided about this case as to whether the appropriation is art historically proper or okay versus the copyright
Those are kind of
constructionists.
You can't have both opinions that copyright law is the basis of everything and believe that appropriation art is art. There's no way to have both. They can't coexist, can they?
Not really, no. And the courts have a real difficult time of deciding whether something is appropriation and okay, kind of okay, and if not. Jeff Koons has won one case, lost another case. I think there's a third one brewing. So it's very difficult for the courts. But I think we're going to get a lot of guidance by the appeal on the Carreau case. There are at least 3 major amicus briefs on the Prince side. I don't know about the Carreau side.
But this case is a little different in that many of the copyright cases, like somebody uses a little picture for some postcard and Jeff Koons makes a sculpture, the postcard guy wasn't too damaged. It's like it didn't hurt his real way of making a living. In this case, this photographer claims that he lost exhibitions and the ability to show his work because it would be seen as a copy of Richard Prince's. So this has like different nuances as well. But if you're an artist, think about your sources. If you're using Disney material, they like to sue people. If you're using Chick-fil or something, some companies like to sue to defend their copyright, because if they don't defend it every time, they're afraid that the accusation it's free for everybody. So if you're taking source material, I might think a little bit just like, don't use Tinkerbell. Okay, maybe use, or Hannah Montana, don't use something else. And then our last area before we take some questions was sort of contractual issues.
One of the key issues, one point about the copyright cases. Copyright cases also have raised some issues for collectors, because if they buy a work that's a copyright infringement, there may be problems with those works. We'll find out, because basically in the Carrier case, the judge ordered that the works be destroyed, and barred the collectors from even displaying the works. So not just artists can have a concern on this subject ultimately, but collectors.
And what's interesting is they accuse the gallery, not just the artist, as the defendant in this case, and that they're saying the dealer has that responsibility too. And this is kind of a first where the third party was accused of the copyright infringement, and they didn't even make it.
No, he gave it to me. Yeah.
But they do get part of the profit from it, so that they have an economic interest in it.
Sure.
So the other area we were going to talk about, probably briefly, has to do with on the issues of buyer and seller and title. The biggest number of cases in the art world are authenticity cases that we've talked about. The second largest industry are cases that relate to title to artwork. And by that I don't mean the name of the painting, but the right of ownership to the work. And this comes up a lot with consignments to art dealers. The most famous one being the Salon O'Reilly Gallery situation, where countless consigners lost their artwork, which was sold by the gallery. Recently, another case was filed involving George Ball, not related to the former Undersecretary of State, against a dealer named Scott Cook. And Scott Cook had hundreds of works by George Ball, and so the suit is now progressing. Cook sold these works to any number of people. There will be issues as to what happens to those and the buyers of those works. So there is concern on one side for the consignor, and then equally concerns on the part of the buyers of those works.
So we'd like to maybe take some questions. There's a microphone, so please wait for that to come.
Hi there, my name's Brian Franco. I'm an attorney in DC. I also volunteer with WALA. I have a question about best practices for young artists. For example, an 18-year-old artist sees a career ahead of him. He walks into your office and he says, how do I work with authenticity at the beginning of my career to put things out there in the marketplace so that I'm warding against people coming up with fake things, or there being some question of, is this work real?
Well, they might put a microchip in the piece of artwork, and that no one knows is there, and then they could have someone come in with a magic wand or something, and then they'd be able to show that. Could be by way of a signature. Signatures are one of the ways. Of course, signatures can be faked, but another way is for that artist to keep really good records of what they've produced. Then when someone wants to determine whether something is genuine, they'll go to the artist, or if there's an estate, they'll go and there'll be a record.
good record keeping, yes.
Yeah. Good afternoon. My name is Jan Walter from the Fine Art Expert Institute in Geneva. You mentioned two cases when authentication was ultimately decided by scientific analysis. Why do you think that those scientific analyses are not performed now systematically on all works of art in case of selling or in auction houses?
The principal reason is that it's very expensive. So the artwork has to be worth a lot of money to think about it.
But what?
And even then, somebody will figure out a way to get that fingerprint onto the back of that canvas in a different way to say, well, it has to be Jackson Pollock. It's got his fingerprint on the back. And, you know, I'm not sure that science can do it all. And we like the notion of scholarliness. Isn't that part of the appeal of art, is this personal thing of, I think this is better than that. If you put it to mathematical model of why it has to be, it loses the allure. And we're all in here because we like the magic of the show. And we like to not know what's behind the curtains too much, I think.
Hi, I'm Shayna Gar, and I work at the Ackland Museum at UNC Chapel Hill. You mentioned that, and we all know this, that the art market is very unregulated and notable because of that. And in both of your experiences, do you have any recommended regulations that might improve some of the situations that come up?
Well, for me, that's a difficult question because so many of my clients are art dealers. However, the biggest single thing that could help would be licensing of dealers. If a dealer was subject to the kind of rules that a lawyer or a doctor are subject to, probably about 9/10 of the people in this fair would not be here.
I would say that the role of ethics should be expanded, and I've argued that the association of the American Association of Art Dealers should have a more vigorous ethical panel that was more open, and if people had to explain their ethics publicly to their peers, to their clients, they might behave better. The only regulation I could think that would be improved is for California to lose their Resale Royalty Act and just stop confusing everything, or the entire country takes this act. Because having this, you know, I'm not sure what other regulation would be good to have.
Very large penalties for treble damages might help on certain things.
Jail time, you should maybe go to jail for longer for stealing, a lot of money than for holding up a grocery store for $30. But
I'd like to modify one thing I said. I don't mean to imply that most of the dealers here are crooks. I only mean to say, well, I'm not. I only mean to say that 9/10 or many of the dealers have violated certain standards that one would expect, which I think, were there licensing, those standards, just as in every other industry, would have an in terrorem effect and cause people to do what they should be doing.
Hi, my name is Francesca Barini, and I was curious about when you were talking about appropriated images in copyrighted works. Is there a general rule of thumb as to how much an image has to be changed to be considered an original image, or would it depend on where the court battle was taking place? Can you hear me?
Yeah, it's.
the question was, how much do you have to change an image? Is it like 30%, 32, 50, 75, 99, 100% to be legitimate? It's like, how much is enough, right?
I don't think there's any number. It's entirely subjective. And with the same number, judges would all have different opinions.
My name is Gretchen Smith, and this is just a little off topic, but I'd like to ask about the trend of the current exploitation of artists to build communities and the legalities surrounding that regarding bank practices and property practices and sort of zoning issues related to that. I know that's kind of a big question.
I don't
I'm
even
sorry,
understand,
I don't understand it
the
at
question.
all.
You're saying
When,
that,
when communities recruit artists to come in and offer them certain advantages to come there, just like they offer other businesses, but those are, in my mind, questionable. A lot of communities offering bank loans that are not legal and sort of having regulations set up and promises made that are not viable.
I'm not familiar with anything like that, so I
Okay.
really can't comment.
I would just say, ultimately, all these things become matters of personal integrity. And if you're an artist, you have to make decisions about whether you want your work to be in a bank that does business in...
No, you're not understanding.
I'm
I'm
not
talking about
understanding your-
predatory lending towards artists.
Excuse me?
I'm talking about predatory lending towards artists for the purpose of building up community.
You're saying, okay, we'll give a bunch of artists loans so that Williamsburg will become a
Correct.
fancier district, so they can live there, and then we're going to then gentrify it after
Correct.
that and displace people. That's your question?
Just curious about the legalities surrounding that type of lending.
I can't speak to it.
It's okay. Thank you. I appreciate it.
Another question that's over here.
Oh, sorry.
I was just curious if there's been any cases with copyright law in reprinting works that had appropriated images. For instance, if you had a small journal or a blog or something like that, and you were reprinting images on behalf of the artist, has there any been, like, I know you said that there were some issues with galleries being sued over and collectors not being able to show.
Individuals have been sued for downloading music and have been found big damages. I mean, bloggers are being sued for putting images up. I mean, anybody can sue you. You know, it's like, and they are. I mean, they've been doing it. They're going after bloggers.
Right.
Don't blog? I don't know.
And then the question is, how much can they take in the blog? That's why a lot of the blogs use links.
There's a lot of places in the art world that use images without permission. And a lot of businesses rely on doing that. And just remember, when you buy a work of art, you don't own the copyright for that work. You own the work. The artist usually retains the copyright. Museums tend to, when they're buying primary works of art, try to buy the copyright along with the work, with the promise that they're not going to use it on a coffee cup.
They never buy it.
They license it?
Insist on it being donated.
As part of the transaction, that they receive it with the understanding that you're not going to put it on T-shirts to sell, that you want to use it for educational purposes. So copyrights, sometimes you don't have the right because you own the sign to make T-shirts for it. You have the right to own the sign. Another question is over here.
Hi, my name is Louis, and I guess my question is, can you provide a little bit more elaboration on sort of copyright infringement in terms of the art world, let's say, versus the design world? Because I know in the design world, it's very easy to knock off, let's say, a Mies van der Rohe chair. And even if Capellini owns the copyright and has the right to produce it, it's very easy for factories to knock it off to the exact dimensions. And there have been several design cases where the chair, the Capellini has gone over the knockoff and can't do a thing about it. Is it different in the art world versus the design world? So is there, for instance, is the nuance of the law that there's some sort of differentiation between appropriation versus straight off knockoff? Am I making sense?
Yeah, I think there is a big difference. I can't explain why, but there is. There are a number of design cases where the designer has been successful. I can't name any off the top of my head, but clearly, I think that in the art world, it's much easier to show an improper appropriation than in the design world.
It's time for, oh, sorry, you have more to
Can
say?
I
Yes?
add to that question? In the art world, is it, in appropriation cases, do you get away with the copyright infringement because of fair use? I mean, sort of parody or?
That's the principal basis of around a pure copyright infringement, and I won't get into the definition of what constitutes fair use because there's a number of elements to it, and that's basically the heart of whether there's found to be a copyright infringement or not.
We have time for one more question, I'm told. So make it a good one. Or not. Okay. Last question here. Thank you.
My name is Marilyn. I have a question. If a visual artist has made a sculpture that has been damaged, and in the artist's opinion, it's damage beyond repair, and
Right.
it eventually goes up for auction, and the artist's name is attributed to the work, even though the auction house has been informed that the artist thinks that it's damaged beyond repair.
Right.
Is there any sort of recourse, or, I mean, is it always buyer beware, or?
Well, ordinarily, if the artist knew about it, they could cause the auction house to withdraw the object and say that it was irreparably damaged and is no longer the artist's work. Then the auction house is not going to be able to sell it as a work by that artist because the artist has disclaimed that it is by them.
To my understanding, in New York State, if it's damaged and then repaired, it's a different story. The artist can, apparently in New York, you can destroy an artwork, but you can't repair it necessarily without permission. So if it was damaged and then restored and the artist said that's improperly restored, you have a much better chance of refuting it than if it's just damaged. And that may only be true in New York State, and I think that's,
I'm not sure I agree, but
well, the Noguchi that they tried to take apart, and there's murals on Houston Street of what to do.
I had a case involving a Kenneth Noland, and his paintings are very hard to restore, and it was restored, and we demanded that Sotheby's take it off the market, and it was. So,
So thank you for coming and asking such good questions.